There was this one matter I worked on where there was a wife swap. 40 years later, these parties start passing away and there's only one spouse left. You had 4 children, well, also stepchildren, biological children, trying to figure out their rights to the estate. I once had to apply for a grant of probate with someone who crossed out someone's name off a will, and the court still recognized it as a brand new will, despite someone's name being crossed out. The deceased traveled to Thailand, had a bit of fun in Thailand, got legally married in Thailand to a person that they met on a night out. 6 months later, they pass away without a will. And under the rules of intestacy, a legal spouse gets the first $150,000 of the estate.
Is it alarming to you that, I think the statistic is that over 50% of Australian adults don't have a will? Melissa Paet, welcome to the show. It's great to have you on board. Tell us a little bit about your practice, your background in law. We want to hear the origin stories of Melissa getting into the legal world.
Okay, so I'm originally from Auckland, New Zealand. I studied there, I got admitted there. I practiced wills and estates in New Zealand and realized that there's a lot of trans-Tasman matters going around with every second Kiwi moving to Australia. So that's how I ended up in Queensland, and now I'm a practicing wills and estates lawyer here.
Okay, so you're currently practicing in wills and estates. Can you tell us a little bit about what that means? I understand what a will is. I write it up, and that means how I'm going to pass things off when I pass away. But what's an estate, and what's that part of working in the law industry?
Okay, so the estate commences once someone passes away. And it's basically a way for the appointed executors or the appointed administrators for them to be able to follow the instructions that you've left behind in your will. So typically it's obtaining a grant of probate from the Supreme Court, and it's also obtaining letters of administration if someone passes away without a will.
So a good way to think of it is wills would be when somebody's living, and then estate is when they pass away. Is that right?
Correct.
Okay, cool. So what are the kinds of strange things you see when people are making wills or when people are leaving their estates behind?
Some common things is that Queensland's actually very, very common when it comes to family provision applications. The first family provision application was actually made in New Zealand. However, it's more common here in Queensland. So if there's a spouse, a child, or a financial dependent that feels like they've been unfairly treated in a will, it's a very common thing, especially with blended families.
So challenging wills, I'm sure a lot of people have heard about that. If they haven't been left adequate provision in a will, if there's an issue with the will, then people can challenge it and say that, there wasn't something left for me. And I think we get quite a lot of inquiries about this in terms of people saying, well, if I'm left out of a will, what can I do? Or can I leave somebody out of a will? What do you see as the main reasons as to why this occurs? Why do people leave someone out of a will? And why would someone want to challenge it if they haven't been left anything in a will?
A very common thing I've seen recently when drafting wills is that estrangement. For example, I had a client probably 3 weeks ago who didn't see her child in 3 months because he was working somewhere else. And people challenge wills is because it's very common here in Queensland, and it's very highly likely to be successful because of the moral obligation of the will maker and their spouse, child, or financial dependent.
So 3 months, not talking to a parent for 3 months. And as a result of not talking to a parent for 3 months, the parent in that situation said, everything that I've worked for my whole life, the last 50, 60 years, you're not getting any of it? Is that what occurred?
Yep, correct.
Look, to me, I would like to think I've got a good spectrum as to what's reasonable and what's not reasonable. And maybe talking to someone for 3 months, there might be various reasons for something like that. Maybe the person was very busy, or maybe they got into an argument. And we all know these things happen in families. People have disagreements. There might be periods of time where they don't speak to each other. So there's often going to be periods of estrangement, let's say, between a parent and a child. And that period could be 1 week, it could be a couple of days, it could be a couple of months, it could be a couple of years. And I've seen it even occur where there's been decades of estrangement, where it's we're just not talking to each other for the next 20, 30 years. And when you die, okay? So, you've got all of these different ranges of time. How would a court kind of interpret what is a duration of estrangement, which would then result in someone not being able to make a claim? So for an example, in the one you said, we're talking 3 months,
Mm-hmm.
but sometimes there might be an estrangement for 30 years. So if a court sees an estrangement for 3 months, they might think, oh, look, 3 months is not enough reason, in their view, that to cut somebody off completely, but maybe 30 years is. So
Yeah.
have you seen any kinds of cases like that where they've looked at the duration and whether or not that plays a part?
The duration is definitely a big thing when it comes to the court's decision making, and it even comes a big thing when it comes to mediation, when we discuss the circumstances as to why someone was left out of a will. What we tend to look at is the onus is on the person making a claim to prove that they try to reach out in those 3 months or 30 years, to prove that there is a financial obligation because they're probably not doing financially well as to why they are bringing up that claim, or there's health issues as to why they can't work and why they are so very much reliant on the estate.
In terms of the common reasons for estrangement, what kind of things have you seen?
Financial disagreements within families, cultural disagreements within families. Sometimes when it comes to upbringing of grandchildren, that also plays a factor in as to why there's an estrangement.
Okay, so basically anything that can go wrong between family members,
Yeah, and I've drafted wills in like a month of January where a client is leaving out a child. 3 months later, they're back wanting to include the child back in the will. So it's
Oh,
a very
wow.
common thing, yeah. And I once had to apply for a grant of probate with someone who crossed out someone's name off a will, and the court still recognized it as a brand new will, despite someone's name being crossed out.
That's interesting, like in terms of having it crossed out, because it might be a little bit hard to prove who did the crossing out and when it was
Mm.
crossed out. I imagine that would have been a little bit of an issue.
So in Queensland, it's really hard to prove what's a will and what's not a will. If there was someone with a will and they crossed it out and they signed it and said, I remove this person, I cross out and sign it, then the courts have recognized previously that it is a brand new will. It is a second will. People can write a will on a napkin, sign it, and get a witness, and it could be granted as probate with the will. If there was an initial consultation where a solicitor will take notes, that person dies a week after, that won't be recognized in the court.
Okay, and the key difference there is what, a signature and
A signature, a proof of intention, a second witness.
is it alarming to you that, like, I think the statistic is that over 50% of Australian adults don't have a will?
It is. It is very alarming. It's something that I argue with my parents because I guess culturally it's really petrifying talking about death.
And so is that what you think the main barrier is? People aren't really ready to talk about their mortality?
Completely. 100%. I agree with that comment. And also the mindset of people don't think or don't know when they're going to pass away.
Yeah.
So it's one of those things where they're trying to just say, oh, I'll do it next week. I'll do it next year. I'll do it next month.
It's like there's nothing pressing about it normally. But I guess there are situations when it does become pressing. For example, people are in hospital, they're just about to do an operation or they're on their deathbed. But quite often we see people making their wills before they go on travels. And, there's a whole range of things that could occur and people maybe get a little bit paranoid, maybe particularly in this climate where there's conflicts and war zones and things like that. So they want to make sure they have their affairs in order. And I know you were telling me a little bit about a case where somebody did travel overseas and something unfortunate did happen to him. So did you want to embellish on that a little bit?
Yeah, so I had a matter come to my desk where the deceased traveled to Thailand, had a bit of fun in Thailand, got legally married in Thailand to a person that they met on a night out. 6 months later, they pass away without a will. And under the rules of intestacy, a legal spouse gets the first $150,000 of the estate, and then afterwards it gets divided between the spouse and the children. The deceased spent their whole life acquiring all these assets, paying off all these mortgages in order for the spouse in Thailand to receive $150,000 and 1/4 of the rest and residue of the estate.
I imagine that didn't sit really well with the kids.
No, definitely not. And believe this, under the rules of intestacy, when it comes to who could administer the estate, this Thai spouse who has not stepped foot in Australia has the first right to be the administrator of the estate and has the right to make the decisions of what happens at the funeral, what happens with the properties. So it did not sit well with the children.
And that could have been prevented. That situation could have all been prevented. Not by not going to Thailand or getting married or anything like that, but it could have been prevented if there was proper estate planning in place.
Yes, most definitely. So if the deceased went to our offices and, created a will and said, I wanted to appoint this person as executor, this is where I want to leave my estate, it could have been completely avoided. We would have raised the issue of the spouse has claim to a family provision application being a lawful spouse. They might feel like they've been unfairly satisfied with the will. However, none of that occurred, and therefore this person in Thailand becomes a beneficiary of an Australian estate.
Look, it all sounds really kind of dramatic, all of these cases. And I think a lot of people would think that, these types of applications and challenging wills and all of that, it's stuff that you see on the news. It's stuff that you see with more expensive, let's say, estates or richer billionaires, multimillionaire kind of stuff. I know there's a huge dispute that's been going on for, I think, decades with the Reinhardts. And there's a big dispute as to how that estate should be administered and divided up. And, people would see that on the news and they'll think, oh, this is mad, and family members fighting one another. But really, if you think about it, your clients, the people that you're seeing, they're not the Gina Reinhardts, and they're not the, the Murdoch family that's fighting over succession pieces and how it's going to play out. They're just regular people, aren't they? And they still have these same disputes.
Correct, 100%. When someone passes away, people tend to think, okay, there's a will. We just follow the will and that's all we need to do. But realistically, if it is a situation such as blended families, then it does become quite an issue because, for example, in a blended family, if the wife was to pass away first and the wife has children, her estate would probably go to her spouse. And the spouse would probably, what people expect, divide the estate amongst the stepchildren and biological children. But people tend to do is after one spouse passes away, they tend to change their will completely to benefit their children.
Yeah, so let's delve into that a little bit deeper. When we're talking about these blended families, of course, it means, you've got a partner and kids with somebody, and then you've probably separated or something's happened, and now you've repartnered, and maybe they've got their own kids as well. And maybe you then have some new kids together, potentially.
Yes.
So you've got 3 different sets of kids, let's say, your original ones, their original ones, and then the new ones. And then it's navigating the dynamic in terms of how much all of the kids should be getting. Should your original biological kids be receiving more or less than the newer biological kids? And what about the other kids that your new partner has? Are they also going to be receiving a portion? What's your view on that, and what kind of advice do you normally give in those situations where you have, this kind of multifaceted, multi-level type of family?
I like to start off from the beginning, and I like to start off with what assets did you actually enter the relationship with? What do you own in your sole name, and what do you own jointly with each other? So that's how I typically like to start. I like to see that when did the relationship between step parents start? Was it through childhood? Then that's probably a moral obligation there. Or was it was the stepchildren in their 30s or 40s when the spouses got together? Because that's when you can establish there's probably no moral obligation of the stepfather or stepmother providing under a will. And it's very common in Queensland, for example, step parents or stepchildren claiming estates of their stepmother or stepfather. So my views on the whole thing is establishing it from the beginning and discussing what are the moral obligations, if there's any, or would it be easier to give specific gifts in the first instance?
Yeah, I've definitely seen a few of those disputes in my time as well, where you've got one party that's passed away and basically most of the estate, if not all of the estate, has gone to the new partner. And the kids from the previous relationship haven't received anything. And then they make a claim against their stepfather or stepmother saying that they should receive a distribution under that. I think that's quite a common type of scenario. It's the classic step parent and the previous children dynamic. It's maybe the kids aren't overly happy with their parent marrying this new person, and maybe there's been a bit of a conflict and it's resulted in a bit of an estrangement. It's like the classic Cinderella kind of story where you've got, the step parent that doesn't get along with the kids, and it can result in that type of conflict. I've definitely seen a few of those. Would you say it's quite kind of common for you to see?
Yeah, most definitely. There's one I'm working on right now where there's an estate and the stepchild got written out of the will after the argument with the stepfather. And now basically it's trying to determine how much of the biological mother's estate actually went into the stepfather's estate.
Yeah, that's right. Because especially if you've got a previous person that's left their estate to the remaining parent, and then that estate has been passed on to the next person, which is the new step parent, then you've got a whole puzzle that you need to start configuring and taking into the equation, right? So that original estate from the first parent that passed away, does that get included in terms of like the calculations, and is that under consideration for the kids of that original relationship?
Typically, yes, if it formed part of the relationship property pool.
Yeah.
I mean, if there is one party who is widowed, owns a property, a new partner lives in that property for 30 or 40 years, it becomes a family home, and they start contributing to the mortgage or upkeep of the property.
Yeah, definitely. So it starts getting mixed together and the lines get really blurred.
Yeah, there was this one matter I worked on probably a couple of years ago where there was a wife swap. So they were friends of each other, and then they just one day decided to swap spouses. And then 40 years later, when these parties start passing away and there's only one spouse left, you have 4 children, well, also stepchildren, biological children, trying to figure out their rights to the estate.
Yeah, that would be I guess a lawyer's breakfast, lunch and dinner as well, because there'd be so many different dynamics to navigate. So what, they all of a sudden decided we don't like each other, we're going to swap partners. Like they must have been all friends, I imagine, from at some point, and one thing led to another.
Yeah, and then they decided to swap partners. And then once they started passing away, the new partners started receiving 100% of the estate. And then now you have stepbrothers and stepsisters trying to figure out what lawfully is theirs under the estate.
And I guess that would get confusing, because wouldn't it also depend on what was left to them maybe from their previous estate, and whether or not they were provided by one of their parents from one of the couples?
Yeah.
And if they were provided there, then that would have been some sort of provision. But if there could have been scenarios where there were kids that missed out from both sets of couples completely.
Yeah, so that was the situation. So once the biological mother passed away, then the stepfather decided to change his will completely and leave everything to his biological children.
It's almost like that in a situation where it does get really messy like that, it would really help if everyone somehow planned this all together, in the sense of like your wills and your estate planning. Like if they knew that, okay, I've got a previous partner. I know this isn't an ideal world, of course, but I've got a previous partner. I need to understand how they're going to be distributing their estate to the kids.
Yeah.
And maybe we should come to some kind of agreement that, you know, you've got to leave something for these people. You've got to leave something for our kids. You can leave something for your current partner as well, but we should both be leaving something to our kids so that they don't receive anything. So they in a position where they're not receiving anything. That requires extensive planning and a lot of, I guess, high-level communication. Might not be capable for everyone, but you know, these things need to be considered, because these scenarios are just going to become more and more complex as time goes on. You see an increase in all of these blended families and different family relationships and estrangements as well. I think it's undeniable that we're living in a society where these things are just going to be more and more common. There really needs to be, I guess, a bit of a wake-up call for people to start understanding their rights and obligations, what they should be doing to plan for the future.
And I would say that's for young people as well. I mean, like if you're in your 20s, even over the age of 18, you don't think about your death. You think about just enjoying your time and having fun and going to work. But there's, especially if you're working in really high risk jobs like the mines, it's probably worth looking into your estate planning and looking into your binding death benefit nominations.
Just let's touch on that, the binding death benefit nomination. Let's go a little bit deeper on that, because on my Instagram account, I actually posted a video that was talking about binding death nominations and your superannuation. And you should have seen the comments and the outrage that people were leaving on that post, just in disbelief, in complete confusion as to what the hell is going on with their superannuation and what is going on with that system. And what is these forms? What's a binding death benefit nominate? What are all these things? You know, like 99% of Australians, like I would say, probably have no idea about what is going on with their superannuation. And I say it all the time. I say, look, when you're in Australia and you're working a job, most people, what's the average age of when people start working in Australia? I don't know, 16, 17, 18, 15,
Yeah. So
20.
they start acquiring super at such a young age.
They start acquiring it at a young age, but they also sign up for it at a young age. And so, you know, like I opened my superannuation account when I was 14, and I'm with the same superannuation company. But, you know, when I signed up for it, obviously I had no idea what I was doing. I had no idea what paperwork I signed or how I opened it up and what it said and what the terms and conditions were. So I can't even recall if they spoke to me about nominating somebody in the event that I die. You know, 14-year-old haters like worrying about this. You know, all he cares about is getting paid $6 an hour at the burger shop. You know, so they are really kind of heavy topics. And I think it often gets overlooked. So when I put up this social media post, people were just so confused as to what I was saying. And I think there needs to be a bit more clarity around it. So take us away here. Tell us a little bit about what we need to do with our superannuation.
Okay, so basically with superannuation, surprise, it doesn't actually form automatically part of your estate. So it is a separate entity where you choose a superannuation company, and it's really important that you have a non-lapsing binding death benefit nomination, because what we don't want is, if it's not binding, if it's lapsing, that means it expires after 3 years. What we don't want is a stranger, i.e. a trustee of that superannuation, making decisions of where your super is to go.
So if you don't have that form, it's up to them.
It's completely up to them. So the stranger is making a decision of where your superannuation is going. And it's a really big thing when it comes to estates, because typically people like to update it online, which one is not binding and probably lapsing. And despite filling in all these forms, if there is another child, if there's another financial dependent, these people can actually make claims to superannuation, and the trustee makes the discretion.
So it's almost like the trustee is the judge here in terms of how they're going to distribute the funds that they're holding on your behalf. Is that right?
Correct. I've seen an instance where there is a disabled child, and there's also a spouse. Well, a child who's on the disability support pension, and then there's also a spouse.
And so what, they had competing, like they were both appealing to the super fund for the funds to be paid out to them. Is that what you're saying?
Correct. And in the will said the rest and residue of my estate to my spouse 100%.
Okay.
And because there is a dependent, a financial dependent that's wanting a claim to the super, 2 checks got sent out at the end of the day.
Gotcha. I can only imagine in your practice how many times a day or how many times in a week you inform people that super doesn't make part of their estate, and they just probably look at you like, are you for real, or are you telling me the right thing here, or
Yeah.
you know what you're talking about? Because I imagine the first, like, that, you know, it would catch a lot of people off guard or be surprised to hear that. Is that what you find? Like there's just a bit of confusion or not really a lot of clarity around super?
Yeah, most definitely. And we have a lot of clients come in and they just say, oh, I put this person's name down, and they don't actually fall within spouse, child, financial dependent. And we like to tend to say, okay, you might have to see a financial advisor because there is tax implications if it's not a spouse, child, or financial dependent, and child is under the age of 18.
Just out of curiosity, who were they appointing in that instance? They're not putting their kid. Was it a friend or a girlfriend or something like that?
It was a friend.
A good friend.
It
I want
was
to
a
be friends with
friend.
this guy.
Yeah, because I mean, if you don't have any relations, if you don't have a spouse, a child, a financial dependent, you still want to appoint someone, because people have this misconception that if you don't appoint someone, it's going to go to the government. And it's a very common misconception people have. And I say, no, it typically goes to your estate if you don't have any of these nominations in place.
Okay. I think that, yeah, that theory has been spread around a little bit. I've heard it a few times as well. All right, cool. Well, Melissa, it's been great to chat. It's a really interesting topic, and I think it's just it's something that touches on every single person in Australia. You know, this topic of wills and estates, and it's becoming increasingly important across the whole demographic, especially aging population and large estates and the biggest wealth transfer in history. This is all the big headlines that we're seeing, and you're seeing it on the ground daily. So it's been good to get that insight from you. Of course, if anyone needs any assistance with wills and estates, you can reach out to Melissa, which is a fantastic solicitor, part of the Justice Network. And we look forward to having you back on the show, Melissa.
Okay, thank you for having me.